So welcome everybody. Welcome everybody who is here in person, and also welcome to everybody who's joining us as well online. It's great to see everybody. And what I'd like to do, just as a bit of information for the people who are joining us online, first of all, is just to remind you to keep your connection muted at the start. The process that we're going to be following in the session today will be that there'll be the presentations by the 4 speakers, 3 of us here in person and 1 who'll be coming in online as well, Laura, and I'll tell you a little bit about that in just a minute. We're then going to have a little bit of a chat amongst ourselves, but with you, about a couple of broad questions that are raised by this topic, and then we'll open up to Q&A from the floor. And again, just for people who are online, if you're welcome to put up your questions in the chat, and they'll be compiled at the end and read out as questions for us. That's correct. Thank you for that. Okay, so I'd like to just begin by acknowledging the traditional owners of the land on which we're meeting, Wurundjeri people, and of course the traditional owners of all the other lands where people are joining us online. I'd like to pay my respects to elders, both past and present, and to all Indigenous people who are also present. So it's a session then. I'm just checking that I've covered all the things I need to check for the actually. Yes, so this session, I put up a slide to begin with just to outline the coverage of the session. So the session is looking at protecting human rights in places of detention with a focus on Australia, looking specifically at compliance with the Convention Against Torture. And we have 4 presenters. The first presenter, as you can see, is Stephen Caruana from the Australian Human Rights Commission. I'll be the second presenter. I'm from RMIT University. And the third presenter, Laura Grenfell from Adelaide University, will be presenting via Zoom. So welcome, Laura. I know she's already here. And finally, we have Deborah, who's the Victorian Ombudsman. So we'll each present, we'll each do a brief discussion on a couple of general questions, and then we'll hand over to Q&A. So if it's okay with you, if you can kind of keep your questions until we get to that stage. Okay, so the first speaker is Stephen Caruana, and a little bit of background. So Stephen is a specialist advisor on immigration and OPCAT, the optional protocol to the Convention Against Torture, which he'll be explaining in more detail, at the Australian Human Rights Commission, and has detention monitoring experience across mental health, corrections and youth justice, aged care and immigration detention. Stephen is additionally a coordinator of the Australian OPCAT Network, a coalition of non-government organisations, academics and statutory officers concerned with oversight of places of detention. And I'll hand over to Stephen.
Thank you, Bronwyn. I'd also like to add my acknowledgements to the traditional custodians of lands on which we meet today, to elders past and present, and to those First Nations people who are with us either in person or online. I'd also like to make a special acknowledgement, particularly given the last session we had, to those with lived experience of incarceration and confinement. It's very easy for us to talk about this, but it's very hard for those people to share their experiences and be re-traumatized from them. So I'd like to certainly acknowledge the strength that was shown in the last session. So before I go into talking a little bit about what the optional protocol to the Convention Against Torture is, I wanted to sort of explain why it's important to me on a personal level and what got me involved in this work. So in terms of the OPCAT, very briefly at a high level, it's a UN treaty that complements the Convention Against Torture, which, as you might know, in international law, there's the absolute prohibition against torture of all forms. It can't be, it's not acceptable, and yet, as we all know, torture and ill treatment continues to occur, sometimes very frequently, sometimes not so frequently. So the OPCAT treaty was established to complement the CAT treaty and provide a what was then at the time of its creation a very practical mechanism for the fight against torture. And what it does is it establishes two tiers of oversight, human rights-based oversight to places where people are deprived of their liberty. The first tier is the Subcommittee for Prevention of Torture, which is created by the OPCAT Treaty, which is a 25-member international body of experts that are elected by state parties that have signed or ratified the OPCAT. So they're at that level, they have the capacity to go into countries that have ratified the OPCAT, visit any place of detention that they like, work constructively with states to prevent ill treatment, but also to identify ill treatment where it is occurring, and to make recommendations and to engage in an ongoing dialogue with the state about how to better protect the human rights of people incarcerated. That mechanism, unfortunately, due to the size and its limitations, will only visit a country about once every 5 to 10 years. So the real power of the OPCAT Treaty is in the second tier of the second mechanism, which is the domestic body, which is called the National Preventive Mechanism, but I'll refer to it as NPM from here on in. And the NPM replicates what the SPT does at a local level. So each country that ratifies the OPCAT is responsible for setting up a national preventive mechanism, either through establishing a new institution or using existing institutions and bolstering their powers to be compliant with the requirements of the OPCAT. And an NPM has the power, again, to visit all places of detention, to make reports on its findings, to engage in discussion with government and state actors, to produce educational pieces to the broader public about how about the harms of detention, about the harms of practices within detention, but also to comment on legislation, policy, and to be engaged much wider, not just within the country, but regionally and with the UN system as well. So that at a high level is what OPCAT is about, but I'd like to now talk about why I'm interested in it and why it's been important to me. From the introduction that Bronwyn mentioned, I've got a vast history of oversight, working in oversight bodies across Australia, looking at aged care, looking at prisons, youth justice, immigration detention, and mental health facilities. But my interest in OPCAT actually doesn't stem from that. It stems from before that. And if you'd like to just move to the next slide, please. So from 2009 to 2016, I worked in immigration detention centres around Australia, as well as the Nauru Offshore Processing Centre for the Department of Immigration and Border Protection, as it was called then. And so I saw from my perspective the very real damage done by incarceration, in particular towards asylum seekers, and in particular, the progression of cruel policies and laws which were designed to really destroy human lives. And so the news grabs you can see on the screen, whilst you might be familiar with some of those, they might trigger memories of remembering when those things occurred. To me, those are very real personal things, because they're events that I was involved in, events that I was at. Of course, in no way do I compare my experience to that of a person who's incarcerated, because of course it's a choice for me. It was a choice and always was. But I think the point that I'd like to make is that working in these systems does damage to the people working in them as well as to the people who are contained by them. And so it was through those experiences, going through riots, seeing people literally die in front of me, that I realized that the wider society has no idea what really happens in these centers. You see the news grab, but that, to me, there are names associated with each one of those events that are with me for the rest of my life. And so it was in that capacity that I realized that the existing oversight that was occurring, particularly in immigration detention, was woefully inadequate. And I can say that because in the 7.5 years I worked in an immigration detention facilities, having experienced all those things, not one oversight body asked me for my view. Not one oversight body approached me and said, what do you think about this? How can we fix this? What are the issues? What are the problems? And that to me was very problematic, particularly towards the end when I was, before I left immigration, I was the assistant director of Christmas Island Immigration Detention Center for 2 years. And even in that position, not one oversight body asked me for my views about what was happening. And I had so much I wanted to say, but of course, due to the Border Force Act, was constricted from saying it. So this was the only avenue in which I could speak. Okay. So anyways, that's a bit about the background and why it's important for me. I think as a former person who worked in there, oversight is so important, critically important, and there needs to be more light shining. I will move on to the next slide. Okay. So I mentioned before that OPCAT has two components. The first component is the Subcommittee for Prevention of Torture. And as I said, they can visit whenever they want. As many of you will know, the SPT tried to conduct its first visit to Australia in October, and it was hindered from doing its work by New South Wales refusing entry to any of their facilities, but also Queensland mental health laws preventing them from entering forensic facilities as well as mental health units. There were also other aspects that were in non-compliance. So while they did visit places like immigration detention, they were not given access to medical files, which contravenes the obligations of the OPCAT. So as a result of the hindrances, the SPT made the decision to terminate its visit, or suspend its visit, and which is in and of itself only one of 4 times it's ever done that, considering it's visited over, I think, well over 90 countries. So from a perspective of our compliance, that's really damaging. From an international relations point of view, I think that sends a really bad message to countries, particularly that don't want to comply with their treaty obligations. But it put us in a very difficult predicament because now the SPT can revisit again, but we're still waiting on some of those rogue states who have said they're not going to comply to basically agree to it. And if they don't agree to it, then of course we'll be in non-compliance and breach of our obligations, which has further ramifications down the track. If I could just move to the next slide. Following the SPT's visit in October, Australia faced the Committee Against Torture for its 6th periodic review in November. And I had the good privilege of being able to attend with the human rights delegation. What was interesting about that was that they made some very specific comments about Australia's OPCAT compliance and what needs to be done. Obviously, they said Australia needs to establish its national preventive mechanism because not all states and territories have done that. So Victoria being one of them, New South Wales and Queensland also being the others. But it also talked about them being functionally independent, being able to have been provided the funding that's needed. It also made comment. They also made comments about what is. They also made comment about an approach that Australia is taking towards its treaty obligations, which is different to anywhere else in the world, and it's this divide between what is called primary places of detention and secondary places of detention. And I think what Debbie said this morning really puts that to the side, because if you're not allowed to go somewhere, it's a prison. A prison is a prison, it's a prison. And so there's this divide about where this oversight body can look at as opposed to where it can't look. But one of my colleagues will talk a bit more into that. And I suppose moving on from here, so if I can just move to, I'll move to the next slide. Australia has up until the 20th of January 2023, so not very long, to meet the full obligations of the OPCAT. And that is considering Australia ratified in 2017, was given 4 years to get it in place, and then provided an additional 1 year at its request. So we are very close to that deadline. And needless to say, I don't think we'll meet that deadline for various reasons, not just because some states haven't ratified, but because the expectation is that we will have a fully functioning national preventive mechanism in place, which will be allowed to visit all places of detention. And until those issues are resolved, we will still be in non-compliance with our opt-out obligations. But as part of the work we've done at the Human Rights Commission, we put together a document called the Roadmap to Opt-out Compliance, and it was really the 5 points that we think need to be addressed in order to be compliant. First of all, of course, every state and territory needs to nominate its national preventive mechanisms. There needs to be the introduction of primary legislation at the federal level to ensure that that NPMs work consistently and it's not a mishmash of different state and territory legislation, which at the moment it is, and at the moment is not consistent. We also asked that NPMs work in ways that are considerate to the lived experience of people, particularly people with disability and Aboriginal and Torres Strait Islander people. One of the other recommendations we make is, of course, the funding issue, because that's been a sore point for over 5 years. Who's going to fund this? And I think the point is, regardless of whether it's the state or territory or the Commonwealth, there's a joint responsibility from all, because Australia has signed up to this. And I think that's the last one. I'm not sure if I missed any, but yeah, thank you for that.
You, Stephen. Okay, so I'm the second speaker, and my presentation is going to be looking at specifically at issues to do with protecting the rights of young people in detention. So if we can just have that to the next slide. Just that. Only got a couple of slides. Okay, so, well, we've all seen the headlines, we've all watched the TV stories about abuses of children and young people held in criminal justice detention in Australia. Back in 2016, we saw the ABC TV coverage of the Don Dale prison in the Northern Territory, use of tear gas, use of spit hoods and so on the children held in that facility. We've heard since then about the overuse of solitary confinement in Victoria and other states, extended incarceration of children in Queensland and elsewhere, and similar issues have been documented all around the world. This past year, we've also had particularly shocking stories in Australia, coming out of Tasmania and coming out of the Western Australia. And just the last week or so, we've seen the launch of a class action in the Federal Court of Australia against the West Australian government about conditions in the Banksia Hill Youth Detention Centre. So, as we've seen in other areas of detention, the inherent power imbalance in these total institutions inevitably gives rise to risks of abuse. I'm just going to make a few points in this short presentation. I'm going to speak to those points anyway. So, first point that I want to make is that the criminal justice detention of children and young people can clearly be harmful, and we should be aiming to stop doing it. Secondly, that we can at least begin by raising the age of criminal responsibility, so fewer children are at risk of detention. And thirdly, that if detention is to be used, it should be subject to rigorous independent monitoring and oversight. And on that point, I'm going to then briefly note a few things that we need to do if monitoring is to be valuable. So on the first point, it's been very clear, it is very clear that detention can be particularly damaging for the development of children and young people. It can affect mental health, it can increase risks of trauma and self-harm and lead to poor education outcomes and harm to family relationships. It's independently associated with worse adult physical and mental health outcomes. So children and young people in contact with the criminal justice system can already be extremely vulnerable. They can come from marginalised communities and have often experienced a range of disadvantage and trauma before even coming into contact with the system. In the Australian context, we know that colonisation has been traumatic for First Nations communities, and First Nations children are significantly overrepresented in youth detention. So the most effective way of addressing this feature of detention is, of course, to stop or at least minimise the use of detention. And strong arguments have been advanced in many forums, including this morning, for moving towards abolition of youth detention. So the arguments I'm making here for effective monitoring for prevention of abuses are not meant to endorse the current use of detention for young offenders. They are recognition of the ongoing use of detention at present, and thus the need for close oversight. So on the second point, we can at least begin by increasing the age of criminal responsibility. This would mean that fewer children would be held in detention, and indeed fewer children would even be at risk of being detained. All Australian jurisdictions set a very low minimum age of criminal responsibility at 10 years, as do a number of other jurisdictions, despite the UN Committee on the Rights of the Child advocating for at least 14 as a minimum age. Many European countries set the minimum age at 14 or 15 in Scandinavian countries. So countries such as Sweden, for example, consequently have very few children in criminal justice detention. And indeed, the Swedish Penal Code proscribes the use of imprisonment other than in the most serious cases up until the age of 21. It's an important point to note. At the same time, Sweden does make a lot of use of secure welfare detention. And that's also an issue that one needs to be aware of in advocating in these areas. So finally, if children and young people are to be detained, it's clear that the international treaties emphasise minimising the use of detention and making sure there are special protections and care for children detained to take account of their developmental age. Convention on the Rights of the Child says, for example, that they're to be treated in a manner consistent with the promotion of the child's sense of dignity and worth. Now, the recent UN global inquiry into children in detention, however, reported widespread failure to comply with the obligation to minimise the use of detention and to ensure that all rights other than liberty are protected. So the topic here is how to address the ill treatment that we know is a risk and is occurring now. So I'll be talking briefly about the use specifically of monitoring, independent oversight as a way to challenge and prevent ill treatment. And I'm asking, how can monitoring regimes support children's rights? How can they be credible and effective? And this is critical now in the context, as Stephen's explained to us, has set out Australia's recent ratification of OPCAT, the development of NPMs, but it's also critical irrespective of whether and when we ultimately have NPMs. We still have to make sure we have effective monitoring in this field. Now, Stephen's outlined the requirements for monitoring under OPCAT and best practice features of NPMs. So factors like real independence from government, proper resourcing are important right now for all the bodies currently doing this work where they exist and bodies that may become an NPM. So what other features are important? So any monitoring process, again, whether under OPCAT or established domestically, has to be credible if it's to be taken seriously and if people in detention are to be willing to participate. So I'm suggesting that there are at least 4 important factors. My second and last slide. Thank you. So we need youth detention monitoring bodies that report publicly, that follow up their recommendations and are seen to do so. Ideally, that have real outcomes, that have child-centred practices that mean children will be listened to, that ensure that children's access to these bodies doesn't put them at risk, and that have staff who are skilled and experienced. So I'll talk briefly about each of those. So first, implementation is fundamental. Studies of implementation in Europe have found very varied responses to the European Regional Monitoring Body, the sort of equivalent body, with only about 1/3 of responses, government responses, accepting recommendations. And in Victoria, the Ombudsman has said very pointedly in, for example, some of her implementation reports, we can all tell the difference between an authentic response and where the box is merely being ticked. In Western Australia, many reports by the Prisons Inspectorate and other bodies had criticised what was going on at Banksia Hill, and this was all ignored by government. Now, so there's an issue with implementation. You know, how do we make it happen? It doesn't always happen. One thing I would note, though, is that monitoring reports, at the very least, perhaps more than at the very least, can also bring evidence of abuses to public attention. They provide a factual base for public knowledge, but also for litigation. So this is the documentation that then, for example, can be used in things like the current class action that's being run in Western Australia. So they have a separate important role. Thank you. Second point then about making processes accessible for children. Does the monitoring body have real insights into what's happening in detention? And the UN Committee on the Rights of the Child commented a few years back that most violence towards children and young people goes unchallenged because of the lack of child-friendly reporting mechanisms. So the participation of children and young people depends on a few things. They have to have accessible information about complaints and monitoring bodies. They have to have information that takes account of their literacy levels, their language requirements. Talking with children in detention requires particular sensitivity and skill. So, you know, using appropriate communication styles, making sure about the safety and privacy of interview locations. And above all, there is the fundamental ethical obligation to do no harm. Third point there, protection from reprisals. Monitoring processes have to address the fact that there's always the risk of reprisals for speaking out. What sort of protections can be provided? Just in brief, for example, there can be assurances of confidentiality of any reporting, and how children are interviewed can be managed. For example, where the interviews take place, whether it's in a group or individually, making sure staff and perhaps other people in detention don't know who's speaking, and so on. And finally, appropriate staffing and expertise. So monitoring staff have to have the necessary capabilities and professional knowledge, and that includes representation of gender and ethnic and minority groups. For example, when selecting inspection staff for particular facilities, they have to have medical, mental health and child development expertise. And of course, they need to be able to ensure that they're using processes and skills that are themselves child-friendly. And in the Australian context, when around half of the children and young people detained are from First Nations, it's essential that there are First Nations staff in the monitoring body, and also that all staff are culturally competent. So it's really important that we're working now on ensuring that oversight mechanisms in relation to children and young people are effective, are credible, and take account of the needs and interests of the children that they're hoping to represent and protect. And I'll stop at that point. And our third speaker is Laura Grenfell, who will be appearing momentarily, and I will then introduce her. Laura, are you there? Can you hear us?
Yes, I can hear you very well. Thank you.
Great, and I can see your PowerPoints are there. So just to introduce Laura. So Laura is an associate professor at the Adelaide Law School. She researches in the areas of human rights and public law, and has a particular interest in how oversight and scrutiny bodies operate in places where people may be deprived of their liberty, such as residential aged care. Thank you, Laura.
Thanks very much, everyone. I'd like to begin by acknowledging that I'm zooming in from Adelaide, where I am on Kaurna land, and I pay my respects to their elders, past and present. Can everyone hear me? Yes? Okay. My focus on this panel is residential aged care in Australia and the need for OPCAT monitoring. And I'll be drawing on some work that I have co-authored with Associate Professor Julie de Beljac and Dr. Anita McKay. And in this presentation, I'll refer to practice in New Zealand and Europe. I know this is an international conference. Now, the first issue I would like to squarely address is, how does residential aged care sit with carceral geography? Is it possible to discuss it alongside traditional places of detention, such as youth detention and adult incarceration. Not so, according to the Australian government, which maintains that all residential aged care facilities, even locked, secure wards, fall outside the scope of OPCAT. Now, as Stephen flagged, the Australian government has decided that OPCAT monitoring will focus on primary places of detention, such as prisons and locked psychiatric units. To reflect on this decision, it's useful, I think, to consider the demography and practice of residential aged care in Australia. So in Australia, we have over 2,700 residential aged care facilities. They are operated by 800 providers, and the aged care population is about 200,000 residents, with less than 10% of these residents living in facilities run by state governments. In 2021, 1 in 5 Australians aged 80 years and over lived in residential aged care, which is a very high proportion compared with other OECD nations. I think 3 aspects of Australia's residential aged care population are noteworthy. The first is that most residents are 85 years or over. The second is that women outnumber men 2 to 1. The third is that most residents have some type of disability, which the Australian Bureau of Statistics defines as any limitation, restriction, or impairment which restricts everyday activities and has lasted or is likely to last for at least 6 months. Now, of those residents with a disability, 97.9% have a profound or severe disability. Almost half of the residential aged care population has dementia, and of this group, they are twice as likely to have 9 or more additional impairments than the group without dementia. So it's clear that in the residential aged care setting, there is a high level of cognitive impairment and of mental capacity issues. And this means that many residential aged care residents are unable to give consent to their placement in residential aged care or their treatment within that setting. The involuntary nature of their placement highlights that this setting is for many residents a form of deprivation of liberty. Residential aged care might be characterised by some as a benevolent site of care, but it's clearly a form of institutionalisation of older persons, one that is subsidised and regulated by the federal government. While residing in a residential aged care facility may be the result of an autonomous decision of an older person, it can also take the form of coerced institutionalisation, where there are few other available options. As mentioned, some residents are under guardianship orders which determine their placement and restrict their movement, and this is de jure detention. Added to this mix is the high rate of restraints being used in residential aged care settings. This is de facto detention, in addition to the restraint imposed by the built environment of residential aged care, namely fences, locked doors, and pin pads. The main types of restraints are chemical, mechanical, and physical. The final report of the Royal Commission into Aged Care found that forms of restraint are being overused in residential aged care. For example, in terms of chemical restraints, the Commission's background paper cited a 2018 literature review establishing that the proportion of residents prescribed antipsychotic medication ranged from 13% to 42%. According to Human Rights Watch's investigation, the use of chemical restraint on people with dementia in residential aged care in major Australian cities is widespread and not used as a last resort. The case that sparked the 3-year Royal Commission was the treatment and subsequent death of Mr. Bob Spriggs at the Older Persons Mental Health Facility in Oakton, Adelaide. Inquiries found that he had severe injuries from the use of restraints, by which he was tied to his bed, and had received more than 10 times the dose of his prescribed medication. According to Bob's wife, he was sedated to ease the management of residents. His bare locked room at Oakden was, in her words, like a prison. So these care practices, in combination with the built environment of residential aged care, which is designed to maximise safety and reduce risks of falls or wandering, allows these places to be closed environments where liberty is constrained. The residential aged care setting allows what would otherwise be considered unlawful treatment to be rendered lawful through substitute decision-making schemes known as guardianship laws. Following the inquiries into Oakden, the federal government introduced the Federal Charter of Aged Care Rights. And it, for example, says, I have the right to safe and high quality care and services. I have the right to be treated with dignity and respect. I have the right to live without abuse and neglect. I have control over and make choices about my care and personal and social life, including where the choices involve personal risk. These rights sit not in the Aged Care Act, but in a schedule to a set of regulations to the Act. None of these so-called rights are enforceable rights. They are soft rights, effectively just symbolic. While similar charters of rights can be found in contexts such as youth detention, these aged care rights are framed in the context of the resident being a consumer of a government subsidised aged care service. So one point of difference from traditional carceral contexts is that under the Commonwealth Parliament's Aged Care Act, residents are framed as consumers, reflecting the significant financial arrangements required upon entering residential aged care. However, as the demography of residential aged care highlights, most aged care consumers are not well positioned to exercise choice. And this is indicated by the very low rate of residents changing facilities where they are unhappy with their choice. Research indicates that residents rarely make complaints, in part because they and their families fear reprisals. In this sense, they have little of the power that consumers are assumed to have. Within this consumer framework, it's also worth noting that residential aged care is an increasingly profit-driven market, where decisions are often based not necessarily about quality care for residents, but how to derive a profit. The pandemic put all these factors under intense focus. This is because older persons have weaker immune systems and are hence more vulnerable to illness or death from COVID, because residential aged care are institutions considered high-risk settings for COVID, and because the pandemic laws introduced by various levels of government meant that access to residential aged care facilities was very limited. Few were authorised to go in or out. And the problem here is that when people are out of sight, they are much more vulnerable to abuse and neglect. So what are the existing safeguards for residents in these settings? The answer here is the Aged Care Quality and Safety Commission, which was established as a response to Oakden. Its monitoring involves assessing compliance with a set of criteria, none of which relate to the human rights of residents. It has the power to make announced and unannounced visits to residential aged care facilities, but it rarely exercises this power to make unannounced visits, in part because the Commission's assessors need to secure the consent of the occupiers to enter the premise and to gain access to documentation. In this sense, the Commission's assessors have one hand tied behind their back. During the pandemic, for a lengthy period, the Commission decided not to carry out any on-site visits. Instead, it asked facilities to undertake self-assessment surveys. and it had detailed phone conversations with each facility. In my view, the Commission's approach to monitoring can be characterised as remote and ineffective. Unfortunately, it's not the independent oversight body recommended by the Oakden inquiry reports, in that it's not immune from government influence. In contrast, OPCAT offers independent monitoring via regular visits, announced and unannounced, using human rights standards. As I flagged at the start, unfortunately, the Australian government maintains that all residential aged care facilities, including locked wards, fall outside the scope of OPCAT. In my view, this position is increasingly difficult to justify, given what I've just said. Firstly, the abuses and ill treatment in residential aged care uncovered by the Oakden inquiries and the Royal Commission. And many of these abuses are arguably similar to what we see in the prison context, but there are actually fewer international standards at play here. For example, no Mandela rules about solitary confinement. Secondly, is the fact that, as you can see on this slide, the UN Committee Against Torture has confirmed that aged care facilities can be places of torture and ill treatment. Third is the fact that in 2016, the Senate Community Affairs References Committee confirmed that Australian residential aged care facilities are places of detention and possibly unlawful detention. Based on the evidence presented to it, the committee concluded with concern, as you can see, that indefinite detention of people with cognitive or psychiatric impairment is a significant problem within the aged care context in Australia. And it's also clear that this detention is often informal, unregulated, and unlawful. So, denying detention status to residential aged care, in particular locked wards, means fewer external and independent oversight mechanisms are available. Now, the benefits of extending OPCAT to monitoring to residential aged care are demonstrated by analysing a report of New Zealand's first OPCAT visit to residential aged care facilities, which occurred during New Zealand's COVID lockdown. So New Zealand made it clear that it considers residential aged care facilities as places of detention because they are places where people are not free or may not be free to leave at will. And this includes privately run care facilities. In early 2020, New Zealand's aged care facilities suffered 5 COVID-19 clusters. The government took the step of designating its MPM as essential services, which permitted the MPMs to undertake on-site visits during the lockdown. And these were conducted by the New Zealand Ombudsman, who has the role of monitoring residential aged care. Now, the aim of the inspections was not to name and shame individual facilities, but to give insight as to how the sector was managing as a whole. So as you can see, they made a number of recommendations, 22 at the altogether, and they were at the system level, ensuring that the practices and approaches of all residential aged care facilities, the 6 they visited and the hundreds that they didn't, would benefit from their recommendations. So here are some of those recommendations. Now, I understand I'm quite close to running out of time, so but the report is worth looking at. It was able to communicate potential preventable problems facing persons who are out of sight, who cannot leave of their own will, and who cannot be visited by relatives. The New Zealand MPM observed that his monitoring provides Parliament and the New Zealand public with reassurance about 2 areas in particular, that the facilities were doing all they could to prevent the virus spreading to those most at risk, and that steps are being taken to ensure the basic rights of residents were being protected. Now, New Zealand is one of a number of state parties to OPCAT to include residential aged care in their monitoring. Under the European Convention for Prevention of Torture, 26 European states have similar mechanisms which cover residential aged care. The Australian government's decision not to include residential aged care in OPCAT monitoring, despite all the findings of the Royal Commission, is deeply troubling. It indicates that the government places a lower value on older people's lives. Its characterisation of residential aged care as a secondary place of detention also places Australia in tension with OPCAT and its international monitoring bodies. This is palpable in the observations published by the UN Committee Against Torture last week, which expresses concern that Australia adopted this distinction, which, as you can see, the last line says, is in clear contradiction with Article 4 of the optional protocol. Now, to conclude, while residential aged care settings may not have all the same characteristics of a traditional carceral context, it's clear that they meet the Article 4 criteria of OPCAT. They are places under the government's partial jurisdiction and control. They can be places where some people are not free or may not be free to leave at will, either by virtue of an order given by a public authority or with its consent or acquiescence. As potentially closed environments, they are settings in which people are at high risk of abuse and neglect. And for this reason, OPCAT monitoring is critical for residential aged care. Thanks very much.
Thank you so much, Laura, and lovely to see you. So thank you for that. And our last speaker is Deborah Glass, and Deborah is the Victorian Ombudsman. I'm sure that's all that needs to be said.
Thanks, Bronwyn, and I'm glad you didn't read out my bio. I too would like to acknowledge that we are on the unceded lands of the first peoples of this country. And I particularly want to acknowledge the importance of OPCAT and this discussion for our First Peoples who are incarcerated in shameful numbers right across Australia. I think it is a national shame. You've heard we've had three really powerful presentations, I think, already about that illustrates the importance of OPCAT, the framework, you know, the context, the reason why these things matter. And what I'm going to talk about in my brief presentation is how it might work in practice. Now, I'm not actually an NPM. We'll get onto that because they haven't, right, Steve? They haven't designated an NPM in Victoria. But I am the Ombudsman. And what does the Ombudsman do? I'm guessing, and I actually also want to acknowledge the people who actually are here in person in this audience. I'm so grateful to you. Hello, everybody who is here online. Hello, everybody in person. But I'm really over talking to myself on a computer screen, and it's just nice to see, actual faces. So looking at those I can see, I'm guessing that you know something about the Ombudsman. You can nod or not. Yes, you do. Excellent. So you know that I'm a constitutionally independent officer of the Victorian Parliament. You know I have a whole bunch of powers, including Royal Commission powers, and I have powers, among other things, to carry out inspections, to require the production summonses, etc., require the cooperation of agencies, and of course I'm the state's human rights investigator. So essentially I'm a standing Royal Commission without the price tag. So implementing OPCAT, what I want to talk about is some of the work I have done specifically in doing that. So as we've already heard from Stephen, some states and territories have got their act together. Victoria is not one of them. And the Victorian Department of Justice and Community Safety is saying that, well, it's waiting on a deal with the Commonwealth and it's all about funding, even though I have pointed out in one of my reports that the cost of establishing an independent investigation function is currently, I think, less than 1% of the state's prison budget. So I'm not sure that's a great excuse myself. So if I can look at what I've done about this, I'm going back in my office to 2017, when we all heard that Australia was finally, after about 10 years, going to finally ratify this treaty that we have heard about and we all know about. And it is also wonderful to talk to a group who doesn't have, I don't have to spell out what OPCAT stands for, as we so often have to do. So back in 2017, I got very excited, like other people in the human rights world, that finally Australia is going to ratify this treaty by the end of the year. So I thought, let's have a look to see what this might look like in practice. What would an OPCAT compliant inspection look like? So I decided to do an inspection of the women's prison, Grenfell Frost, and as you can see, you know, this is what we did. So I sent in a team of 12 people. They are in their op caps. They weren't really wearing them, by the way. That's just, you know, we just use op caps for our team. But what they were doing, team of 12, and they actually went in to Grenfell Frost. And we did a lot of work at the time on the methodology, because what we wanted this to be was as compliant as possible with an OPCAT, as they would have been done in the UK by Inspectorate of Prisons and so on. So we were liaising closely with other, you know, with designated NPMs. Well, what do you do? What standards do you apply? So what did we find? And I'm going to skate through this. These reports are all online. You can see them all for yourself. But we were in there with a team. We took photos. We liaised with individuals. And there are many findings, and their report speaks for itself. But one of the key findings in that inspection was about the unnecessary use of strip searching in the women's prison, which, as I commented at the time, actually was re-traumatizing on so many of the women who actually had experienced sexual abuse. So it was a pretty shocking finding. And I remember being particularly shocked when looking at the women's prison as compared with all of the men's prisons. I think it had the second highest use of force of all of the prisons around the state. And you know, that in itself was really quite a shocking finding when you're dealing with an essentially compliant population. So very, very stark. The report generated quite a bit of interest, as you can imagine, got quite a bit of publicity, and it actually didn't talk about OPCAT at all, I think, in any of the material, but it didn't really pick up, other than, you know, the human rights community, who noticed that this was, thank you, you know, Stephen and Bronwyn and others, you know, who noticed that the Ombudsman was seeking to carry out an OPCAT compliant inspection. What might that look like? But what it did do was expose this particularly compelling issue for female prisoners. And interestingly, my recommendations are very, very broadly accepted. I think I have a 95% acceptance rate. This was one of the very few stopping these strip searches that was not accepted. But guess what? The practice changed. So that's something that I describe as the nudge of the Ombudsman's elbow. What of course I also recommended in that report, for those who've read it, is about the importance of, you know, we explored also NPM structures. What might that look like? I did a lot of research on that, again, with the assistance, among other things, of one of my co-panelists. And we made, you know, recommendations about, you know, what that might look like in practice. So we get to ratification at the end of 2017. So states and territories are now obliged to do something, but hey, presto, nothing happens. So I thought, well, I might have another look at what an OPCAT compliant inspection would look like, and let's try something different this time. So in this case, I thought I would do a thematic inspection, and I don't know that this has ever been done before. You know, what we decided to do for this one is look at the issue, a single issue, solitary confinement, across 3 different facilities, across secure welfare, which is where, you know, teenagers are likely to be placed, youth justice, and the adult prison system. So we were looking at really the Mandela rules. I think everybody's heard of the Mandela rules. I'm not going to explain them. What does this mean? Well, as you can see, 22 hours or more without meaningful human contact. What does it look like? You know, what does solitary confinement look like in the Victorian context? And we did a lot of research. We sought contact with lots of NPM bodies around the world where this is actively these things are much more actively monitored than here in Australia. So we did this, and the other, you know, the next thing I did was set up an advisory group. Again, this was I don't know whether it's a world first, but it's certainly never been done in Australia. Because what I wanted to do was bring the experts from the Children's Commission, who really know these things, from academia, and Professor Naylor actually was a member of my advisory group, and I brought in civil society in addition to academia. We actually brought in representatives of the Human Rights Law Centre and the Victorian Aboriginal Legal Service. And there's something about bringing people into the tent here. Give us some advice. Where should we look? Which facilities should we go at? Where does the problem lie? And even more, I think, ambitiously, we seconded some of those people onto our inspection teams. So we actually had multidisciplinary inspection teams that included representatives of other statutory bodies and even members of civil society, which I think was pretty radical. But incredibly effective and incredibly, I think, successful. So, they were sharing their expertise and their intelligence, and it meant that we were able to do what you're supposed to do under OPCAT, which is bring in that really full multidisciplinary approach to how you do the business. So we looked at 3 facilities. Our inspection teams had we engaged with them. They had keys and radios. That we actually were able to get out there and do what you would expect a team acting as an NPM to actually do. And it included a broad range. So it included my staff, people from the Children's Commission, again, an Aboriginal lawyer from the Human Rights Law Centre, and we also borrowed the lead inspector from Her Majesty's Inspectorate of Prisons in the UK. So, we had not only a multidisciplinary team, but we had an international expert to assist us. We had mental health and disability experts also seconded in to help us on the forensic side. So it wasn't just a couple of inexperienced OMBO officers, going out there not knowing where to go. It was a really multidisciplinary, really professional team. And we did this over 3 weeks, spending a total of 12 days in the 3 facilities, and speaking with young people, speaking with staff, in addition to just looking at the papers, looking at the records, and looking at who was going to go where. So classically, as you do, and what we were trying as much as possible to follow what a good NPM would do, you triangulate your evidence. You are seeing things, you are reading things, you are doing surveys of people in the facilities and the staff. What do you think? What's your experience of this? And you're putting all of this evidence together and coming up with a report. So I just want to give you a few examples of what we found in this, which I thought was actually fascinating. So one of the first things we learned, of course, was that solitary confinement doesn't exist in Victoria. That term you will not find in any of these facilities. But what do they call it instead? They call it isolation. They call it separation, seclusion, or lockdown. Not solitary confinement, just isolation, just, seclusion, and so on. And again, one of the things we acknowledge, these practices are not inherently bad. These are difficult environments. Sometimes you need to separate out young people for their own safety, for the safety of others. So it's all about how do you manage things, respecting people's human rights, the rights of the individual, the rights of others they may be with. How do you do this in a way that that respect as much as possible, bearing in mind the challenging environments that people are in. So let me give you an example of Jake. We called him Jake in our report. This is Jake's story. Now, Jake was abused as a child, and he was exposed to substance abuse, family violence, the usual horrible story of so many young people who end up in, I'm afraid, in our prison system. So traumatic childhood. And of course, in that traumatic childhood, he ends up in secure welfare. He goes into youth justice, and then he ends up in an adult prison. And it was actually quite compelling that we found the same individual had actually been in all 3 facilities. And what we were able to find, and this really shocked me, was he's obviously engaged in disruptive behavior. And very similar forms of his disruptive behavior had very different consequences. So let's have a look at this. His disruptive behavior in secure welfare results in isolation for 2 hours, in youth justice for 5 hours, and in adult prison, 432 hours. So very similar forms of disruptive behavior result in this. So let's move on to another example here. This is, we call him Jasper. Young person who is assaulted by another prisoner, put into solitary confinement, and each of them gets 45 days. So he's attacked, he's isolated for the same amount of time as his attacker. So pretty horrible. So a quick quote from Youth Justice, because we, that was a place that we were particularly interested in seeing, how are they doing it here? Very mixed picture. And what you see there is that there is there are people in the system who really care about young people and really want to support their rehabilitation. But they also felt that that's, as you can see from this quote, the only tool they had was isolation. And we found that was actually pretty depressing. And we actually also felt it was fear of negative headlines that resulted in that. So I made a lot of recommendations in that report. As I say, read it for yourself. I recommended a preferred NPN model in Victoria that utilised all the experience of the advisory group, the multidisciplinary work we had done, all the things that, that had seemed to have succeeded really well in the context of our practical work. And of course, the government's done absolutely nothing about it. So I wait to see. It's been accepted in principle, but hey ho, it's, let's see, where are we? The end of 2022. Finally, and I'm surprised nobody else has used this quote, but I love it, and we use this fairly regularly. This is just a reflection that OPCAT is global, that the experience of people in prison are universal. When you're deprived of your liberty, you're deprived of your liberty, and the nature of human rights is universal, isn't it? So OPCAT, we've again reflecting on the theory and the practice. It's a remarkably practical treaty. It's a rare, practical, human rights treaty that really can have positive, real, practical consequences for people deprived of their liberty. So look at what happened with strip searches. Think about what might have happened in, would we have had a Royal Commission in Dondale if OPCAT had been implemented in the Northern Territory? We can refer to all the scandals right around Australia and ask ourselves, would they have happened if there had been, if OPCAT had been around, if those places had been inspected? Or if there had been an expectation that they were going to be inspected, which actually, more than anything else, stops things happening because the inspectors might just turn up. So that's it. Very disappointing that in Victoria, at least, and most of the major states, we are yet to implement. But I live in hope as the Ombudsman. I always live in hope, and very happy to hand over to our facilitator to take any questions.
Thank you. Thank you. Well, I think that what we might do is start off by throwing it open to questions. I've got a couple of points that I'd love to run by the panel. I think first of all, I might just see whether there are questions from the floor. Might start with the people who are here in person, and then Beck will see whether there are questions on phone. Okay, so yes.
Hi, my name is Rosie. I'm a lawyer in the prison advocacy program at Fitzroy Legal Service, and we work with people across Victoria in prison, focusing predominantly on human rights. It's very limited resources. One lawyer, myself, 4 days a week across all people in prison in Victoria. It's unsustainable, to say the least. In terms of moving forward with our program and hearing what you are saying today about NPMs, and I think I would just like your opinion or comments on the place for human rights legal centres. And I know that, Deborah, you touched on it, that you engage community groups in your oversight mechanisms. But how can we play a role in this moving forward with OPCAT, and how we can better be supported in the process between now and when we have an NPM in Victoria, noting that, resources for legal support for people in prison is notoriously bad, especially in Victoria.
Yeah, look, keeping up the good work is really all I can say. It is enormously frustrating because it is it is a constantly resource-strapped area, and there's no money in human rights, is there? So all I can say is keep up your advocacy. I think we should not be silent about how shameful it is that Victoria has not yet. But how extraordinary is it that that a modern, originally world-leading state in prisons has been unable to designate its NPM. So keep up the good work. I don't have an answer to this one, I'm afraid. I'm really sorry. We just have to fight the good fight.
I think by its nature, the OPCAT has to involve civil society, whether that is through legal services or advocacy services. And I think what Deborah did here in Victoria is the model that all Australian states should follow in terms of that engagement. Because if you look around the world, that engagement with civil society is usually found in two ways. That's through advisory boards or through actually attending and being part of a monitoring team. And of course, Deborah did both, which is fantastic. And yes, it was the first time it's happened in Australia, and hopefully not the last time either. The OPCAT in itself provides opportunities for civil society organizations to bolster their work. So in saying that, that there's the idea that there's this two-way street where you can provide information to the NPM when it's about to go look at a prison, like what are the issues that it needs to look at, where are the particular parts of a prison that are problematic, because you're the people who are there more often than the NPM itself. But also on the reverse side, the reports of NPMs are really important for civil society organizations in their advocacy work. And I know that one such step is strategic litigation, which was talked about recently. So for instance, the Public Interest Advocacy Centre launched litigation with regards to immigration detention and the handcuffing of vulnerable people who were going for medical appointments or torture and trauma counselling. They were able to use the public reports of the Commonwealth Ombudsman and the Human Rights Commission as evidence, because we were saying the same thing. We were saying that this is a practice that shouldn't occur. People are not going to medical appointments because they don't want to be humiliated by having to go in handcuffs where there's no risk at all. And so it's that two-way street. So I think there are going to be more opportunities as the NPM matures, but certainly, you've got the model here in Victoria, and I think that'll just develop.
Thank you. Yes, up to back there. You'll need a mic as well. So just while you're getting the mic, I was also just going to say, we've just seen an announcement by the Tasmanian Prisons Inspectorate that's going to become the NPM, a specific invitation to civil society organisations to give them feedback they can input in due course on their model of the NPM and how it should function. So actively engaging with civil society. So that's a really valuable model as well. That is the Tasmanian. Oh, it's the Tasmanian Ombudsman as well. The Tasmanian Ombudsman, Prisons Inspector, NPM, and everything else. That's right. Yeah.
Thank you. Thank you for such a great panel. My name's Amy Nethery. I'm a political scientist at Deakin Uni. I have a whole list of questions. If you allow me, I'm just going to ask two really quickly. It's one of the things that I would like some clarification on, because it is a theme of all of the papers, but I don't quite understand it, is this sticking point between the Commonwealth and the states regarding OPCAT. And I understand, the ratification of international law and so forth, but could you spell it out for dummies, please, why this is such a sticking point in Australia? If you will allow me my second question, Bronwyn, it was just something that I've never understood about the low age of incarceration of children in Australia, leaving aside our histories of racism and colonialism and so forth. But why does Australia have the minimum age of 10 compared with everywhere else? How did that happen historically? Thank you.
So thank you. Thank you, Amy. We had two questions. On the first question, why is Australia the way it is when it comes to A, ratifying, but B, implementing international treaties? Stephen, did you want to comment?
Sorry, Stephen.
I'm going to resist the urge to bang my head on the table when I provide this response, but I think you have to go back. You have to go back and look at the context. When OPCAT came into place, previous governments looked at it and thought, should we ratify this? There were two reports, I believe, 2009, I think, and 2012, which said at this stage, we don't think it's necessary. So there was a lot of resistance from the beginning because, again, when this came out, it was a revolutionary treaty because it's a practical treaty. It means you have to do something about it and not just change laws and not just window shop policies, etc. The ratification in 2017 came off the federal government wanting a seat on the Human Rights Council. So it had made a pledge to ratify OPCAT because multiple countries, states had said, you need to do this. And so it decided, it said, we're going to do this so we can get that seat. So obviously it was a decision of the federal government, which at the time probably was not consulting the states and territories, or at least from their point of view, they had no objections. They had not raised objections to it. The other factor that you need to look at is, of course, the Dondale Royal Commission. It was an easy win to say we're doing something good here. And the Attorney General at the time did state that had OPCAT been ratified, what happened at Dondale would not have happened. So, you know, from a federal point of view, it was a good thing to be doing. But very early on, when they were looking at an intergovernmental agreement on OPCAT, it became apparent that there were several states that were resistant to it, and they used the funding issue as their sticking point, saying that, well, the majority of places of detention are under the responsibility of states and territories. Therefore, if the Commonwealth is going to ratify something that puts the burden on us, it has a responsibility to fund it in an ongoing manner. That has been the issue for the past 5 years. There is so much on the public record from multiple states and territory attorney generals saying that we will not do anything. We accept this in principle, but we're not going to do anything until the funding is agreed to. But really, the funding is a moot point, as Deborah said. You know, the cost of setting up monitoring on an ongoing basis is relatively minor. I think it was the Green senator who raised it in Senate estimates a few years ago. Nick McKim said the cost of funding Christmas Island Immigration Detention Centre for the 6 months when it was opened for the Tamil family was the equivalent of funding the Office of the Inspector of Custodial Services in Western Australia for 27 years. So funding is really not an issue. It's just a matter of principle now that states and territories are just resisting for the fact that they can resist. And it was clear, particularly with New South Wales, in their Senate estimates before the SPT visited, they said that this issue would come to a head when the SPT visited. So there was that veiled threat that we're going to make sure that the Commonwealth is embarrassed, and they didn't. And so where to from now? The Council of Attorney Generals, or whatever they're called now, met recently, I think last week, and they're saying that the Commonwealth is saying that it's requested costings from every state and territory. And I know that each state and territory is putting forward its proposals, hopefully the best proposals, because they're expecting the Commonwealth to fund it. But as I said, we only have until January 20 to get this up and running, which we will not get up and running just due to the fact that we've got a New South Wales election coming up. We've just had Victoria's election. So those states that really aren't, Queensland, yes, it's put forward some legislation, but it still hasn't designated an MPM or have legislation in place. So there are multiple factors at play, but I think, at its core, it's just states and territories not wanting to do something just because the Commonwealth said you have to do it.
Thank you, Steve.
And I suppose just to add to that, I mean, the fundamental question is, what difference will it make? As in, there's no mechanism of enforcement. There's no mechanism of enforcement of these international obligations other than public embarrassment. And Australia seems to have managed to not be that worried about public embarrassment in previous periods of time in relation to international criticism of its approach to international and domestic human rights. But maybe with the change in federal government, that will make a difference. But as Stephen was saying, in the end, it's coming down to what the states are willing to do as well, and what they see as significant in terms of reputation. On that other question, I mean, there's a long answer and a short answer, obviously, on in terms of why we have the age of criminal responsibility that we do. The simple answer is that when Australia was colonised, we took on English common law and English approaches, UK approaches. The UK, Australia, New Zealand all have the age of 10 as the minimum age of criminal responsibility, along with the age of 14 as the period between 10 and 14, when it can be argued that a child does not have the capacity to know right from wrong. So there's kind of in between bit, that concept of Dolly in CAPAX. But we have that 10-year minimum age limit. I think historically you'd find that it was a theological concept of the capacity of a child to sin and to understand the concept of evil. And so there was the concept, it was felt that by 10, a properly educated child would know about good and evil and would understand the meaning of sin. So fortunately, there's been developments since then around the world which have looked at evidence and issues around child development and so on. And there have been shifts to higher age limits, although there's plenty of evidence to suggest that you should be looking at 20, 21 at least in relation to what the growing knowledge around development of the capacity to understand consequences and so on. So we do have, there's quite a few countries have now moved to 14, and the Committee on the Rights of the Child has said it should be at least 14 or higher. And so 14's become the age to which most campaigns are directed. And that's the current campaign in Australia. I don't know, it was being discussed at the Standing Committee, whatever it's called now, of Attorneys General in Australia last week, I think, and I'm not sure what came out of that. There's been discussion in a couple of jurisdictions of moving it to 14. I think the ACT, Northern Territory has introduced legislation, passed legislation, I think, moving the age all the way to 12. And that's not going to come into effect until the end of next year. So I think hopefully the increased recognition of the evidence will be what changes things, I think. But obviously there's always the competing pressures of popular punitivism and fear and so on that make it difficult to get this up. But it does seem to be, there does seem to be some momentum now. Others may know more than I do about that in terms of where it's moving politically, but hopefully.
Yes, we just have a question on Zoom.
Yes, no, we have a question here as well, I think. We'll take a couple of questions online, if that's okay.
So this question is from Mark Yin and asks, I know Laura touched on the role of profit in the aged care sector or the role of private corporations in general. And they wanted to ask the other speakers how profit might influence their respective areas of inquiry.
Okay, so the question is in relation to the impact of profit on willingness to provide for rights protections, I guess.
Just how profit might influence their respective areas of inquiry.
Yes. So would someone like to?
I can answer that in the context of private prisons in Victoria, and I can say very simply that they are in my jurisdiction, and I would apply exactly the same standards as I would to a public prison. So it would make, to me, no difference at all. I'd be expecting to see full compliance, and I would be commenting unfavourably, if not.
Thank you. And I know that the question asked other panel members, but Laura, would you have anything a further comment there? Because it's been a very striking feature of the aged care sector. I think that the sort of state and for-profit sort of facilities. Whether you've got anything else you'd like to say about that?
What the statistics show us is that the number of residents in privately run facilities is increasing. I think it was 41%, so it's becoming more of an issue. And certainly in New Zealand, this was not a barrier for the MPM there to be able to inspect privately run aged care facilities. And I'm hoping that that will become the same in Australia once the Commonwealth accepts that residential aged care facilities, at least for locked wards, should be part of OPCAT monitoring.
Yes, I mean, I think it's clear under the OPCAT that it really applies to any place where a person is deprived of their liberty that's run by a state or authorised by the state. So that would apply to both private sector and public sectors, to representatives in prisons. I think it's also been any facility, yes.
Publicly funded.
Yes.
Private facilities.
Yes.
Come under ombudsman's jurisdiction.
Yes. And I guess in the aged care sector, what we saw was that that's been relevant to the operation and the conditions and so on as well. I'll just hand it over to Stephen to make quick.
Yeah, of course, privatisation is not just about aged care. I mean, disability group homes is privatised. Immigration detention is run by a private company. So it applies across the board of every place of deprivation of liberty. But through an OPCAT lens, that doesn't change how it's viewed. The human rights standards apply regardless. You're not looking at whether they're cutting corners to save costs. You're looking at the actual impact on the people on the ground, the people who are being mistreated or the way they're being treated. So I think whilst it's something that OPCAT monitors will have to keep in mind, clearly in mind, as part of the work they do, looking at the broader picture of the context, I don't think there's a difference between the standards that you would bring to a public prison as opposed to a private prison, because human rights is human rights. So that's probably all I need to say to that.
So I think given the time we've got, we can take two more questions. I've got one here and we've got one online over there.
I thought we would even skip the last question. Thank you very much for these great contributions. My name is Julia Manek. I'm a human geographer and clinical psychologist based in Frankfurt. And I'm also working for a human rights institution in Germany and in Mexico. And being between academia and practice in the field, it seems sometimes like that there is some parallel words existing, while Alison Mounts, for instance, is talking about the triple death of asylum, referring to death of migrants, but also to the death of asylum as an idea and as laws that are kind of killed, or asylum laws that are like kind of, sorry for my English. And so then I see you and listen to you, and you say, for instance, I have power, which is true, and at the same time, sometimes it feels that it's just not true, seeing like given all the politics of deterrence that we can see, where like purposefully the same states that have agreed to certain human rights norms just violate them in a highly visible manner. So what would you then answer, like towards like being confronted with the triple death of asylum, for instance? Sorry, it's
obviously I don't deal with deaths, and there are other systems that are set up. I used to actually back in my old job, so I'm very aware of the shocking nature of these and the importance of independent investigation when you are dealing with that scenario. But if I can address it really in the context of powers and enforceability, because I think that's also in your question, am I right? Yeah. I mean, as the Ombudsman, I have the powers of a Royal Commission. My powers are not enforceable, and that is deliberate. So I can, because I don't control the state budget, I don't control government policy, and many of the things I recommend involve the government should spend money on something, the government should do something, the government should, change the law or stop a practice. So what I have, and this is true of ombudsmen, I think, around the world, I have what are known as the persuasive powers of the office. I have the power to table my reports directly in Parliament. And what I'm working on is the power of the evidence in the reports, the impact that has on public opinion. And sometimes that can be incredibly effective, and sometimes it is not effective enough. So it all depends. As I say, I think I mentioned earlier, 95% of my recommendations are not only accepted, but implemented. That's a pretty good track record, considering I can't enforce any of them. And I monitor them. So with something like strip searching in the women's prison, I reported on that. They didn't accept it, but they did it anyway. I found the same thing with the hard lockdown of the public housing towers here in Melbourne. I said the government should apologise. They did a really poor job in dealing with 3,000 people's human rights, which they breached, in my view. Again, they didn't apologise, but they did it very differently next time. So enforceability will take you so far. It is not the answer. You have to be more subtle sometimes in the work we do, and working with civil society, working with the media, working with academia, working with everybody, in this room and beyond. All of these things are what propels change in a democratic society.
Yeah, I'd have to agree with Deborah. I don't think there should be enforceable powers, because when you make recommendations that are enforceable, you become part of the system and you're accountable for those changes. And sometimes they may not be the right change and they may have adverse impacts, but it's about shining a light on the issues and allowing the system itself to not be able to hide from those issues and have to do something about it through that persuasive power, through those public reports, which then make it a public issue. And there are certainly a lot of evidence of MPMs across the world which have directly and indirectly led, through their work to changes. So, for instance, in New Zealand, there was the issue of tie-down beds, which were used to strap down people who were at risk of suicide. So they were strapped down to beds from their hands, feet, arms, body, head, and they couldn't move. They literally could not move. And that was their way of dealing with people who were at risk of suicide, by placing them on a bed, strapping them down and leaving them there for 24 hours or whatever it was. As a result of the work of the Ombudsman in highlighting that, in actually calling that a torturous activity, and noting that in other countries, particularly in Scandinavia, that it is outlawed because it is considered torture. That practice was stopped immediately as a result of that. And then 2 years later in law, it was banned. So that's a result of persuasive powers, not enforceable powers, and really highlighting that issue. Then you have other examples, such as, I think it's Paraguay or Panama. They did a thematic inspection of children's institutions. And as a result of that reporting, the powerfulness of that reporting, they closed down 7 institutions and placed those children into family situations. So, there's a direct link to deinstitutionalization. There are many other examples, so powerful examples. So in the UK, after an inspection by the prison inspector of Her Majesty's prison in Birmingham, because of what was raised at how bad the conditions were, it was run by a private corporation, G4S, I believe it was. The UK government immediately revoked the contract, kicked them all out, and took control of that because of the concerns the prison inspector had that someone is going to die if you don't do something now. So there are, you can see there are powerful examples of where these mechanisms can work directly and indirectly. And I think if you're talking about the asylum, the immigration space, looking at it now, I mean, I can't speak to what the Commonwealth Ombudsman does, but I know what we do in the Human Rights Commission. Just one example, I'm not going to say it directly led to it, but we announced to the government that we were going to do an inspection of all the hotel APODs in Brisbane and Melbourne, particularly with a focus of Melbourne, because that was post the Djokovic issue. And so we said, we're going to do this. We started to seek submissions from civil society. We made it very clear what we were going to do. And what we hoped was just announcing that we'd get people released. And all the people in Melbourne got released just after we announced. I'm not saying that's a direct link, but it's that whole intention that, just them knowing that we were going to come there was enough. We hoped was enough to persuade them to be like, okay, we better do something about this. So So yeah, I think that's the power. It is the power of persuasion, and it's only as powerful as the public gives weight to it. So that's why that's that real importance of joining with civil society whilst remaining independent, but also having civil society amplify the voice of these MPM bodies.
I'm aware that we're a bit over time, but we did begin late. So obviously, if people need to go, please, feel free. But we do have one online question, and I would be very sorry to not give that person the chance to ask their question. So as I say, feel free to move on, get lunch if you need to. Otherwise, we'll just address this one last question. Thank you.
Yes, and this question is from Damia Hayden, who is the policy lead at Change the Record, a First Nations-led Justice Coalition. And the question is regarding dual office holding. So they've seen at least one of the ombudsmen, who's also an MPM, raise concerns in their annual reports about being under-resourced to do their ordinary work, let alone on top of their new NPM responsibilities. Do you think this approach is in Australia's jurisdictions is a deliberate attempt at avoiding scrutiny, or maybe a lack of creativity in policy making, or something else?
Okay, well, I think Deborah definitely wants to speak about this. Not an uncommon problem, and not an uncommon problem in other countries as well that have ratified and implemented OPCAT. But Deborah.
Yeah, thank you for that question. And I'm really clear that designation as an NPM, whoever is designated, so if it were my office, for example, that I would expect that it would be resourced appropriately on top of my other work. It would be separate from it. It would need to be carried out in an entirely different stream, because it's not ombudsman work. It's a different way of working. It's preventative. It's something that an ombudsman can do. Actually we're very experienced in the prison environment, but it is not the same as an ombudsman investigation. And part of the work I did in those two OPCAT reports was really to highlight what the difference would look like and how differently it would operate. Resourcing is, I think, crucial. It's a requirement, along with the independence of the role, the independence, the powers, the resources, the ability to report directly to Parliament, all of these things, to monitor recommendations, all of these things, which ombudsmen can do, are important, and they're all important. So what we've seen with the designation, some ombudsman officers have been designated, some more may well be. And I'm sure that my colleagues, if they were to be designated, would be saying the same as me. We need specific resourcing to do this function because it is a different kind of work and we need to do justice to it.
Yes, so thank you for that. Thank you. I think we will need to, got no other questions there. No, so that's great. So I think, thank you so much for your presence, both in person and everyone who's online. Thank you so much for your questions. I think it's been really stimulating discussion. So I think we'll finish up at this point. Thank you. And of course, thank you to the panel members. I should have said that as well. And to the wonderful tech people.